Hello, this is Dave Siegel and welcome to Legal Action. Today we're going to be talking about Chapter 13 bankruptcy, some of the misconceptions surrounding bankruptcy, and also some bankruptcy alternatives that you may want to consider if you're struggling with debt. I'm joined once again by Jesse Barrientes.
Good afternoon, Dave.
Who's a well-known DuPage County attorney and general practitioner, and he's with me to give some insight on Bankruptcy Chapter 13 and the things I talked about previously. Welcome.
Thank you very much.
How are you?
Very good, thank you. It's just a wonderful evening. We mentioned earlier about talking about the misconceptions. What I suppose one of the first misconceptions that people always have is, am I going to lose all of my property when I file a bankruptcy?
Right. People are worried about that, but in reality, they get to keep the majority of their property because the state has exemption laws. Exemption laws are laws that allow you to protect your property free and clear while eliminating your debt or in preventing someone from collecting upon a judgment. And just recently this year, the exemption laws in Illinois were doubled. So whereby $7,500 was the exemption amount that you could protect in a home before this year, it's now $15,000. So if you have a married couple, you combine the two, you can protect $30,000 worth of equity in your home if you're married.
And still file for debtor protection under
And still
under the
file for
bankruptcy law,
Chapter 7
13.
bankruptcy relief, that's right. The other exemptions have doubled too, so where in the past you can only protect $1,200 in a vehicle, you can now protect $2,400. You also have a wild card exemption which you can put towards any piece of property. That went from $2,000 to $4,000. So once again, a married couple example can protect $8,000 worth of miscellaneous property. Bank accounts, furniture, TV, jewelry, electronics. So in other words, Illinois residents can protect a lot more property than they ever could and still file for bankruptcy relief.
Well, another issue that people often bring up too is they feel kind of embarrassed because they're filing for bankruptcy and they really don't want anybody else to know about it. So one of the other misconceptions is that people are going to know about the bankruptcy when I file it, and we both know that that's not necessarily true. Right. For example, what would be an instance where somebody would know? If you were a high-profile case, maybe?
A celebrity case, somebody would find out about it, the papers would pick it up. Your employer may know about it if you have to notify them to stop a wage garnishment on your job. But if you're worried about your neighbor knowing or your co-worker knowing, the likelihood of that is almost nothing. They would have to go down to the bankruptcy court or log on to a restricted website and search for your last name to find it among the recent filings. And who in the world is going to do that just to find out that you filed a bankruptcy?
Oh, but the truth is it's a matter of public record, but nobody's really going to take all that effort to try and find out about a particular individual.
That's correct. There's about 4 lines of copy that are printed in the Chicago Daily Law Bulletin, which looks like it's the size of the Chicago Tribune, but really only attorneys read it, and things have to be published in that paper just to qualify under certain state statutes. So really, no one is going to find out about it unless you want them to find out about it, or if you owed them money, or strike that, if they owed you money and they had to be listed as a creditor or a potential benefactor, they would have to be listed on your schedule. So that's a little bit of an exception.
Because they would receive notice pursuant to the statute as they're entitled to receive.
Right.
But those are really the only reasons why somebody would know about that.
Right.
Well, another common misconception for bankruptcy is people always think that they're not going to be able to get credit ever again. Now, it's tonight we're talking about Chapter 13. And it would last, and we're going to talk a little bit more about that later, 36 or 60 months or some period in between there in terms of the repayment plan. But after that period of time, people are going to start to receive solicitations from credit card companies because they want their business and they know that they've just gone through a bankruptcy and they're completed with their payments. So after that time, they're going to receive those solicitations. The only difference is that they're going to have a higher interest rate on those particular cards. But if they continue to pay after they get through the period of time for the bankruptcy, if they continue to pay all of their bills on time and they're timely with everything else, then after just 2 short years, that percentage rate will go down dramatically. And of course, it will never be as good as it was before they filed the bankruptcy, but it will go down and they'll be able to secure credit cards and they'll be able to secure a mortgage on on a house as well.
That's true. There certainly is life after bankruptcy. In fact, a lot of my clients are inundated with credit offers after they have filed. And there's a couple reasons for this. First of all, if they filed a Chapter 7 bankruptcy and eliminated their debt, they're not entitled to another bankruptcy discharge under Chapter 7 for 8 years and a day. That means if they take out credit, they're going to have a long time before they can possibly eliminate that debt. Credit card companies know that. They know these people are a good risk. They've already eliminated their debt. And the credit card companies are hoping that my clients will take out the credit, continue to make high interest payments for years and years and years. If you think the credit card companies are doing you a favor by extending you credit after a bankruptcy, think again. It's in their best interest, not in the individual's best interest.
Well, that recently changed. Didn't it used to be 6 years in a day for somebody to be able to file another Chapter 7 bankruptcy?
That's correct.
So they've tacked on 2 more years as a result of the new bankruptcy code to try to make it a little bit more difficult for somebody to do that.
Yes, the bankruptcy laws effectively changed on October 17, 2005, and the law is basically more harsh against individual consumers than ever before.
So it benefits the credit card companies a little bit more.
That's correct. Instead of 6 years and a day to refile, it's 8 years and a day. Debtors have to take a credit counseling briefing before they're eligible to file. And this has really backfired because Congress's intent was that if people went to a credit counseling briefing, they might decide to repay their debt through non-bankruptcy means, like a debt consolidation, payment plan, something like that. But what we're really finding is nobody, or almost nobody, is taking them up on that offer. If you're a debtor and you're drowning in debt and you've gone to see an attorney, and an attorney tells you, well, you have to take this credit briefing to qualify, and you take it, you still want to file bankruptcy. You are still in trouble. No briefing in the world is going to create more income for you, more disposable income to pay your debt. So that's really backfired, the credit counseling.
So I just have to hop through another couple of hoops in order to get what I wanted.
Hoops, hurdles, whatever you want to call them, that's the biggest one. And it's not a big deal. Clients can take it over the internet, or they can take it over the telephone with an 800 number. It takes about 45 minutes to an hour, and the charge is $50. And we've just put a little check next to that being done, and they go on with the rest of their case.
And that $50 goes to the credit counseling agency. It doesn't go to the bankruptcy attorney or to the trustee or anybody else. You know, I've heard from some feedback from some of my clients that certainly when they call, because not everybody has access to the internet. I mean, as strange as that may sound today, okay, right, that they're not able to get any sessions to be able to do the class for months in advance. I just recently had somebody who said the next available time for them to get something was like in mid-March, which is it's a little scary. I mean, you would think as you institute a new program that you would have the resources to be able to absorb the enormous volume of people that you know are going to be there.
That's right. It's about a 2-week waiting period by phone with the companies that I've used too. But I encourage clients to find a computer, go to the library, there's internet access, find a friend or someone who you can sit at their computer and get it done in one shot in about 45 minutes.
You know, another common misconception that people have or questions that they have is, will, you know, when they file for bankruptcy, will all of their debt be wiped out? You know, for example, I don't know, I might have a few parking tickets or maybe some student loan. Well, no, I just kind of hypothetically, I haven't received a parking ticket. I'm not claiming it, okay? Right. But those kinds of things, or maybe some taxes that I didn't pay just because I didn't have the money. So are those kind of, will everything get wiped out when I file a bankruptcy? Or?
It depends on the person. It depends on their debt. Chapter 7 will cure a lot of bills, but it won't cure all of them. Some of the debts that stick around are student loans, recent taxes, parking tickets that you mentioned, child support, alimony. Those debts stick around after a Chapter 7, but hopefully the individual has eliminated a lot of credit card debt, miscellaneous personal loans, auto repossessions, utility bills, other debts that we can eliminate, so that the ones that are not eliminated, they can at least afford to make some kind of payment plans and rectify it that way.
Sure. You know, some other questions that I get from clients and that they want to know, and it's a misconception, is whether or not when they file a bankruptcy, whether or not they have to list all of their creditors. Because, hey, guess what? I really don't owe this particular credit card any money. There's a zero balance. I might have a couple cards like that, and I really want to keep it because, I might decide to charge something again.
Right.
Am I going to be able to just list the creditors that I want? Or maybe I have this credit card with just a little balance. Maybe it's $50. Is that something that I'm going to have to list on my schedule?
People love their credit cards, don't they?
They do. They really do.
They want to keep the credit cards. Unfortunately, though, you must list all the debts that you have. And that means any credit card that you're carrying a balance on must be listed, and you're going to lose that card. Now, if you have a zero balance, you don't have to list it because technically it's not a debt that you owe. However, the credit card companies subscribe to a service which indexes the Social Security numbers. They find out about the bankruptcies, and then it's up to those credit card companies, even the ones that you don't owe any money to, it's up to them as to whether they want to keep you as a client or not. And more likely than not, they will cut your charging privileges.
It's very important to kind of talk about maybe some of the alternatives to filing a bankruptcy. Bankruptcy really is meant as just the last kind of frontier. It just, when you're between a rock and a hard place, and when somebody finds himself in that situation and they have no other place to turn, they can always turn toward the statute for that kind of protection. So it's kind of really a remedy of last resort. So some of the alternatives that people can do is, one example of an alternative would be to try to negotiate directly with the credit card company. Now, it may be kind of difficult, and it really depends on how many creditors, credit card companies that you do have. But if you have a history with them, and perhaps you're in the situation that you're in because of some calamity, maybe it's divorce, maybe someone passed away, maybe it's medical bills, some tragedy, they may work with you. You might be able to reduce any payments, to renegotiate some kind of a payment plan with them that's a little lower. Might be able to get rid of the past due payments.
There's a couple of problems here, though, if I can interrupt you.
Sure.
What do you have to negotiate with?
Well, the only thing you have to negotiate with is the prospect that I'm going to file a bankruptcy.
They don't care.
Yeah.
Typically, they don't care. They'll take the write-off. They'll take the tax write-off.
They will, but you know what? This is my philosophy. You will never know until you ask. And, that may very well be, and actually, in a lot of circumstances, that's it. They really don't care, and they continue to do that. But you don't know. And, if for somebody that has maybe one credit card with the debt on that, and they've kind of gotten a little bit behind, rather than file a bankruptcy, it can't hurt to ask. All they can do is say no, and all you can, do is maybe do what you were going to do in the first place, which was, maybe to file a bankruptcy. Right. Another alternative is to try to get a consolidation loan to pay off your credit cards. And there's a couple issues with respect to that. You get a consolidation loan and you pay it off, and what that means is now you're not going to have to worry about the interest rate that you have with the credit cards. You're going to consolidate everything, so you just have really one place to pay. Right? And then you're not going to have to worry about overdue fees and those kind of things. But the difficulty is if you're in a position that you're having to do a consolidation loan, probably you're not going to be able to get one. You agree with that?
Right. You're also incurring more debt to pay off other debts. In a sense, you're robbing from Peter to pay Paul. And where are you getting the loan from? Are you taking the money out of the equity in your home, the equity that you may be able to protect right now under Illinois law, and still file a Chapter 7?
Well, a lot of people, sometimes that's what they'll do, and I've seen many people, even friends, that will try to take a consolidation loan again and again and pay off their credit cards. And what they're not realizing is what they're doing is they're turning credit card debt, which is going to be dischargeable in a bankruptcy, into debt which is no longer dischargeable because it's now secured by their property.
Right.
As well as cutting into the exemption that they're going to be able to do.
And they're possibly putting their home at risk if they don't have the ability to pay that consolidation loan.
That's absolutely correct. Kind of one of the last alternatives is to talk to a credit counseling service. To be able, this is one of these places where they try to consolidate everything for you. They might be able to negotiate things where you failed on an individual basis with the credit card companies to kind of maybe reduce the amount of the payment that you're making, and to be able to kind of maybe get you from a past due status to a current status, and to be able to reduce or completely knock out some of the late charges. But again, we have the same issues and same difficulty. What is the motivation for the credit card company to allow them to do that?
In my experience, too, I don't see the debt going down in any reasonable time period. I see it basically staying the same, or sometimes even going backwards. A lot of the fees, a lot of the interest that gets paid doesn't go towards the underlying debt. It goes towards some administrative expenses of the credit counseling company. And again, it's all to benefit the credit cards, not to benefit the debtor.
And you really have to find a good company. I've heard from clients that have had really bad experiences with that sort of thing, and even to the point where after that they've had to really do a consolidation, which is what a Chapter 13 is, right?
That's true. It's true.
Yeah, you talk a little more about that.
Well, Chapter 13 is basically what I call bill consolidation through the court. It lets you reorganize your debts and pay off your debts over an extended period of time, while at the same time stopping creditor collection actions, stopping foreclosures, stopping repossessions, dead in their tracks while the debtor is making an honest effort to repay his debts.
So that's why I would file a Chapter 13 is if, and we've mentioned about the exemptions, the $15,000 per individual. So if there's a married couple and maybe we have we'll have $30,000 exemption, but say maybe we have $75,000 worth of equity in our home, and we're a little bit behind. We're behind maybe on some other things, car payment. Isn't that really why I would file a Chapter 13 to be able to hang on to those possessions?
One of the most common reasons for filing a Chapter 13 is to save a home, to save it out of foreclosure, to stop a sale date, to take the mortgage arrears, the part that the person has fallen behind on their mortgage, and repay that portion over time while being allowed to make the regular mortgage payment again. And this is kind of tricky. Let me explain what happens here. An individual falls behind on their mortgage, and they can't make one lump sum payment to get caught up. They can make small payments, but they can't make the lump sum payment. And the mortgage company a lot of times says, well, if you can't pay it in full, we're not going to accept any small payments. So the only way a debtor can save his home in that case would be either Chapter 13, which is repaying the arrearage over time, somehow refinancing the property, or selling the property. So it's very difficult to do the other two, especially when they want to save their home. So Chapter 13 is a viable option.
And I do know from experience from some of my clients that talking to those creditors in those situations isn't really going to get you very far in terms of, and you're absolutely right, just they won't accept a partial payment. They want the whole thing or nothing. So now, you mentioned too that you have to keep current. So basically it's the arrears that get thrown into the bankruptcy?
Right. When we're talking about real estate and mortgage arrears, the only part that gets thrown into the bankruptcy consolidation payment would be the arrearage portion.
So if I'm behind, say, maybe 4 or 5 months, that's the amount that's going to go into the bankruptcy. But when I file that, I'm going to have to what? To keep current then? To pay whatever the next scheduled mortgage payment is supposed to be?
Yes. Once your case is filed, you as a debtor are responsible to make your next regularly scheduled mortgage payment on time, as well as on time for every continuing month. And the mortgage company, once they get the Chapter 13 bankruptcy notice, they are aware that they have to again accept the regular monthly mortgage payment.
Now, you make a very good deal here in terms of it has to be on time when you make that payment. Because if you waver from that, what can the trustee do if, say, I don't make a payment, or I don't make a payment at all with respect to keeping my house current, right, my mortgage payment? What is the consequence of me doing that?
Well, Chapter 13 can only work if the debtor makes timely payments. If the debtor fails to make the trustee payment, which is the consolidated payment, the Chapter 13 trustee will bring a motion to dismiss the case, and then you're right back where you started again. If you fail to make the mortgage payment on time outside of the bankruptcy, right, that mortgage company will come in on what's known as a motion to modify the automatic stay. And they're basically asking the court for permission to avoid the bankruptcy and begin their foreclosure or continue with their foreclosure efforts. So you have to be perfect when you're in a Chapter 13.
That brings up another good issue, which is a payroll deduction situation where the money to fund the plan for the Chapter 13 comes directly out of your paycheck.
That's correct. It's probably the best way to guarantee that you're going to make your Chapter 13 trustee payment timely is to have it come out of your check. That way you don't have the obligation on your own to write the money order or the cashier's check and send it off. It's coming out of your wages. There's one problem though. You're still going to have to make your regular mortgage payment on your own. So you've got that obligation. And remember, for a successful Chapter 13, you're going to have to make both the Chapter 13 trustee payment and your regular mortgage payment. It's a very hard deal because you're repaying your debt. So you're not only making your current mortgage payment, but you're paying a little bit extra towards your Chapter 13. And you're doing this for 36 to 60 months or a shorter period if that's what it takes to pay off your debt. But it's a very difficult proposition, but it can be done.
Now, what about my car? I mean, nowadays we have situations where people don't just necessarily own cars, but they lease them as well. So, is there any difference whether or not I own a car or lease a car? Is that going to be inside, included in the bankruptcy estate? Is that going to be outside the bankruptcy estate? Can you give us some guidance on that?
Sure. If you're leasing a car, you continue to make the leased auto payments directly like you always have. If you are financing a vehicle, the entire vehicle balance, or at least the secured portion, gets paid through the Chapter 13 trustee. So you will not make a car payment again if you're financing an automobile. That vehicle debt will be paid along with your mortgage arrears and all of your other debt.
So I'm actually really in a better position if I finance the car and I haven't leased it.
I believe so, because you can extend out the payment. 36 months, 60 months is typically longer than you may have originally had on your auto loan. And another important point is if your car was purchased more than 2.5 years ago, you can pay back the secured value in full, which is the actual market value of the vehicle in full, and pay the unsecured portion possibly less than 100%.
So is what you're saying that suppose the car that I have, I owe $50,000 on it. And it's
what kind of car is this?
Well, it's a Mercedes, but
should have known by the suit.
I know I should have, but it's one of the lower models. But suppose I've got that car and it's I owe $50,000 on it, and doggone it, it's only worth $25,000. From what you said, it sounds like that I'm only going to really have to repay the actual current value, which is the $25,000 and not the $50,000, is that?
Typically on a normal car that's the case, but you may run into a problem where the court deems that car a luxury vehicle. And in that case you will be penalized because you can't pay back a luxury vehicle less than the fair market value under certain circumstances. But if it was a normal car, a $20,000 car, a $15,000 car, your example would be 100% correct.
And is that the term for that is called, the technical term would be?
Luxury vehicle.
Well, the term of that principle, that'd be cram down.
Yes, that would be cramming down the actual amount owed to just what the secured portion is, what it would sell for in the open market.
Chapter 13 has a lot of different names for it, and sometimes it's called a wage earner plan. Is that right?
Right, a wage earner plan, but that's really a misnomer because you can fund a Chapter 13 from other sources of income. Disability, unemployment, rental income. You don't technically need to be a wage earner, but it is referred to as that sometimes. But it's also referred to as a reorganization plan, a consolidation plan. But Chapter 13 reorganization is how I like to refer to it.
So in a Chapter 13, you actually need to have some kind of excess funds from wherever your money's coming from, right? Whether or not it's your job or from the other sources that you mentioned, to be able to fund the plan to pay something to the trustee.
Right. You have to have what's known as disposable income. That's income above and beyond your expenses each month. If not, you don't have the ability to repay the debt, and you either need to do a Chapter 7 or liquidate some of your assets if you're not willing to do a Chapter 13 if you don't have the income to support it.
Now, when you do the petition, there are various schedules that go along with the Chapter 13 petition, right? And just kind of basically, you want to list, what is it, your assets, your liabilities.
You have to list everything you own, everything you owe, specifically what you bring in per month, what you spend per month, a statement of your financial affairs, which entails what you've earned during the last 3 years, what you've earned other than a job in the last 3 years, if you've given back property, if anything's been repossessed, if you transferred any property, if you've closed a bank account. It really is a detailed storyline about yourself and your financial situation.
And part of that is listing your expenses. But there's a difference between what I might deem as an expense and what the trustee is going to accept as an expense. Just an example might be food. Say I spend, I don't know, $800 a month on food. We just like to go out and eat and to go to restaurants and to enjoy some really nice food.
I think that's a little unhealthy, and also the IRS guidelines would say that it's excessive.
Well, what am I allowed? I mean, in terms of what the IRS guidelines would say would be allowable?
The IRS guidelines are based upon the area in which you live and what an average family would spend on food, transportation, housing. And if you're spending more than that, the trustee is going to cut those down, or you're going to have to justify why you need to spend $800 a month on food.
So generally, if we're looking just kind of the most general average, $350 for one individual for food?
Sure, that would be fine.
$50 for each additional person that's in the household as well?
Right. What you want to do is really sit down with an attorney and go through your income and expenses, and the attorney will let you know whether your expenses are within reason or whether they're excessive.
What are some advantages for Chapter 13?
Well, Chapter 13 allows you to repay your debt over time. It allows you to save a home out of foreclosure. It allows you to repay an auto debt for possibly less than what you owe. It allows you to repay otherwise non-dischargeable debt. For example, parking tickets. You can file a Chapter 13 on parking tickets and extend out your payment plan over 60 months while undoing any kind of suspension on your license for incurring those parking tickets.
So I'm still going to have to pay them back. I'm just going to have a little bit more time to do that.
Yeah, you've mentioned parking tickets a couple times. Is there something you want to say?
I'm not claiming that. I have a lot of clients who have parking issues or other issues. Another good issue is people that don't have insurance and they get into an accident. And when that happens, you
have a couple of choices there.
That's right.
Either repay the amount owed, or you're going to be suspended. Work out an installment payment plan with those people, otherwise you're going to be suspended. Or file a bankruptcy, Chapter 7 or Chapter 13.
Which is going to allow me to keep my license and to be able to drive and to make a living.
Right. Chapter 13 could be a very viable option for someone who has assets or someone who has disposable income above and beyond their expenses per month, whereby they wouldn't qualify for Chapter 7. But I want to say that Chapter 13 is tricky. It's not something that you should try on your own. It's something you should definitely talk to an experienced bankruptcy attorney about, to sit down and see if a payment plan would be feasible. Final thoughts on Chapter 13, Jesse?
Final thoughts. A lot of people are talking about joint debtors, where maybe they have grandma or mom on the hook for another debt. And it's very important to understand that as long as you're maintaining the plan and you're doing what you should do and making those payments, that co-debtor is completely protected under the Chapter 13.
Yes, if they're paying that debt back 100%.
Right.
Otherwise, the co-debtor's at risk. Thanks for joining us, Jesse. I really appreciate it. Nice having you again.
Good evening.
I'm Dave Siegel. We'll see you next time on Legal Action. Take care.